Cover three topics. We're going to cover jury selection. We're going to do that this first hour. In the next hour, we're going to talk about opening statements, and I'm actually going to do a part of the opening statement I did in trial last week that was successful. And while I want to talk about that in the next hour, we got some great feedback from the jurors, which I want to share. And then finally, I'm going to talk about closing. So jury selection. What hasn't been said about jury selection? There's so many great gurus out there. We all know them. We've all read their books. You know, David Ball, there's so many great resources. So I was very intentional when I put this program together to take a lot of time and just kind of reflect on what I'm doing that's now working versus what I was doing before, which was not working. And that sort of sparked some ideas that I think will be useful and hopefully things you can take back to your practices. Dan asked us to sort of frame a case and talk about a case in context. I'll talk to you a little bit about is the case of Barbour versus Piedmont Newnan Hospital. And what I love about this case is the defense lawyer, some of us here know, was coming off a 50-0 win streak, and he loved to tell people that. And this was a case that the client didn't look injured. So the client's name is Mike Barbour, 42 years old, working goods, married, 2 kids, strong guy from south side of Philadelphia, sort of tough guy. And he had some chest pain, goes to the hospital, and they said, well, we're going to keep you overnight. We're going to do a nuclear stress test and just check your heart in the morning, make sure everything's good. So he goes in the next day. And if anybody knows about nuclear stress tests, parts to it. There's the resting phase and there's the exercise phase or the active phase. And the idea was put a catheter, and then the next morning they would inject dye. It gets taken up into the heart. They go and they take a picture of his heart. Then they put him on a treadmill, inject him again. It gets taken back up to the heart so they can have something to compare with. So he goes that morning, and the nuclear technician did not confirm that the catheter was actually in the vein. It was in the vein the night before, but the next morning, apparently it got lodged and nobody checked. So they inject this material in the arm. All of a sudden, it infiltrates and starts bubbling up under the skin of his arm. Nurse screams out, "Oh my God, I forgot to flush the vein," she later disputed that, but multiple people in the room said. Wrap his arm in a towel, they send him back to the lab to be said, it was a direct quote that he owned, "How the fuck did this happen?" Sounds like a great case. Yeah. The mic's funky. Let me make it with a handheld instead.
Hey, can I say one thing too I forgot to say? The process is if you have questions, we're going to hold those, and you can email them to...
I'll give them the address.
Okay.
See if this one works. Is that better? Yeah. I should have said this on the outset. If you have questions throughout this, email them to Mauricio, Mauricio, at belllawfirm.com. Mauricio at belllawfirm.com. He's in the back of the room. He's going to sort of curate the questions as we go through it, and then we'll do the questions at the end. So hold them if you can. All right, so back to the case. So this is what happens to Mike Barbour. It sounds like a great case. We thought it was when we signed it up. But the problem was he developed a complex regional pain syndrome. Has anybody dealt with CRPS cases, RSD cases? Right. Very challenging cases. The person looks fine. You know, they don't have, a lot of times they don't have any visible symptoms. And that was Mike through and through. He looked fine. He kept working, but he had this chronic, unremitting pain in his arm. So fast forward to trial. We're trying the case, and the defense brings down the best-looking expert I have ever seen. This guy's 6'4". He looked like a Norway Olympic skier kind of guy, and brilliant, credentialed, all those things. And he comes off the stand, and I invite him to. I said, well, would you? One of the big issues in dispute was whether there was the diagnosis was accurate, whether there was truly CRPS. And we made a big point that there was a temperature difference in my client's hands, which can be a sign of CRPS. So we invited the witness to come off the stand and actually do an examination of my client in real time, which was kind of crazy. Who lets an expert ever touch your client? But we knew we had to sort of take some chances and do some things a little differently, or just weren't going to win it if we tried it the traditional way. So he comes off the stand, touches my client's hands, and predictably he says, no temperature difference at all. So at that point, we turned to the judge and we said, well, Your Honor, can we have the jury touch my client's hands? They can tell temperature. Anybody that's ever had a child knows how to tell a temperature, and hot, cold, it's comparing. And big fight, defense lawyer had an aneurysm, it looked like. And in fact, he was blubbering so much about objecting that what got taken down on the record was, Your Honor, I object, the evidence is too relevant. That was actually what was in the official record. Anyway, so of course, we fight this big fight. The jury says, or the judge finally says, yes, it's okay, and won the big fight. I turned to the jury, and nobody's volunteering to touch my client's hands. And I plea with my eyes, and finally, this one juror says, well, I'd like to touch his hands. And it was like a religious sacrament. He touched my client's hands, and then the next one touched hands, and the next, and the next, and the next. And I talked to the defense lawyer afterwards, and he said, I knew at that moment that we had lost the case because there had been that connection. So the concept of connection has stuck with me ever since. And you can't always get the jury to touch hands, but we're all about connecting people. And I think about that in jury selection. Get through this case. Just some of the visuals we show the jury in that case, all the changes in his condition. This particular graphic, the jury said, was very, it hit them particularly hard because the guy looked great, but nobody would take that kind of medication if they weren't serious. So this is about jury selection and the tools that you need for jury selection. There's really only one tool that I use. This is it. I use a musical stand, and I would recommend everybody get one. They're super lightweight. You can keep your notes on them. They're very helpful in jury selection, particularly because you can have your different chapters of areas you want to cover, which I'm going to talk about more in a minute. But in contrast, if you're behind a podium, and even if it's a not a real thick, impressive podium, but you're still behind a podium, so you want to get away from the podium as much as you can. You want to interact. I mean, if there's a podium between us here, it's a whole different experience. But if you use this little stand, which I'll use, I put it off to the side, and I have my notes, and you can tilt the top so people can't see how many questions you're going to ask, and they can't make any kind of judgments. But then you can just get closer. You can get more engaged. What you don't want to do is be taking notes. Everybody probably knows this, but you don't want to take your own notes. You don't want to have a pen in your hand. You don't want to have a clicker in your hand. You don't want anything in your hand, any obstacles between you and the juror. Because this is the most important, jury selection and opening statement, I believe, are the most important phases of the trial, without exception. More than cross, more than closing, more than anything else, because this is where the initial impressions are being developed, and views on you, your credibility, your ethos, all those things. So if you can reduce all the barriers and notes and have somebody else taking detailed notes for you, nothing in your hand, just you and the juror. So I originally entitled this "The 7 Rules of Jury Selection." That seemed a little pompous because there are a lot of different rules and ways to do it. But I did want to distill sort of 7 principles that I follow when I'm doing jury selection. The first one is immediate engagement. Okay, now we say that, and people say, well, you got to be nice and all those things. I mean immediate engagement. Okay, So when the jury, everybody has probably some variations of our sort of jury system, but when the jury is first meeting and you're first encountering them, it's so tempting to get your head down in your notes, or to be writing down all their names in a grid. All those things are barriers. My goal is to have nothing in front of me and be doing nothing except greeting them in the morning. And there's no reason you can't say good morning to every single juror. People feel like, well, you can't look at them, you can't smile. Completely disagree. So I'm very intentional in jury selection to be looking at the jurors and saying, good morning, and just kind of half smile, just to sort of lighten the mood a little bit. Everybody says there's no room in jury selection, there's no room in trial for laughter, for jokes, that kind of thing. Totally disagree. It's a human experience, and it can feel dehumanizing to the juror, but when they walk in and they see somebody who is open and isn't taking notes and studying them like a lab specimen, but is engaging with them, it can be very, very powerful. So immediate engagement. Now, this is something I've started doing in all my trials, and sometimes the judges don't like it, but most of the time it works. And I like to get the jury moving. Well, how do you get a jury moving in jury selection? Well, and I don't know if I think this is being recorded, but hopefully this won't come back and bite me. The sort of subterfuge I use to get them moving is I say that they need to stand up so they can look around and see if they know anybody. Now, this is Atlanta. We've got 6 million people. Very unlikely they're going to know anybody. But what I'm doing is I'm inviting them to get on their feet and say, does anybody, we've got a lot of folks here. Say you're my jury panel. I see a lot of folks in the back and around, and does anybody know anybody? And just to make sure, would everybody just sort of stand up and look around and look at your neighbor, and if you want to say good morning to them, that's fine. It's an opportunity to kind of lighten the mood. But there's something that happens when people get up on their feet and they're looking around, and you're gaining information. You're creating when people are moving together, it's subtle, but I believe it's real, that people start feeling like they're a unit, they're a group. It also gives you the idea to learn information about people. Some people get up slowly than others. Some people will get up and reach for a cane that you may not have seen, or stand up slowly, showing they have some sort of back issue. So you're gathering information, but you're also creating the impression that you're leading and you're getting engagement. The whole gateway to persuasion is engagement. You've got to get people to buy in and recognize that what you're doing is meaningful work and that they're part of a meaningful, purposeful process. So number 2, and this is a change in my practice, lead with issues, not process. And some of the great books, I won't call them out by name, but some of the great books, they talk about starting off with, has anybody ever been in a jury selection before? Anybody ever, civil case, criminal case? Do you remember the standard of proof? How many people remember the standard of proof is this way and not that way? And these sort of process questions. So the jury is sort of left with this idea of, it's kind of boring. They're not able to put things in context yet. They don't know what the case is about. So instead, what I recommend doing is figuring out, and obviously you've identified what the key issues are in your case, lead with that. So in a medical malpractice case, if the issue is misdiagnosed cancer, lead right out of the box. Ladies and gentlemen, if you are chosen to serve on this case, or sometimes I'll say if you're called to serve on this case, I think that's a little much, but if you're picked for this jury, you're going to learn that this case involves misdiagnosed cancer. So I need to ask you about some of the issues involving cancer. So now you're communicating information to them. Jury selection is more than just gathering information from the jurors. Of course, you're educating the jurors. You are conditioning the jurors. And do not let anybody, in my humble view, advocate that jury selection is not for conditioning the jurors. It absolutely is, because these are human beings who are persuadable, and they are taking on information, they're processing, and you are communicating that this is a serious case, and these issues are important. Now, once you have led with issues, and it might be issues related to the standard of care, it might be issues of causation, whatever the key issues are that you want to start introducing to the jury, you still have to get to your process questions, but you want to do that later once the jury sort of understands in their mind. Oh, this is a case, I got it. Yeah, this is doctors being accused of not, checking a lab result or not communicating with his witness. So, they're starting to put the pieces together. Once they start putting those pieces together, then you get into your process. Then you get into the standard of proof, burden of proof, what that means, what that looks like. So lead with the issues, not the process. Sari de la Motte does a lot of good work on this topic in her book, and I would highly recommend that to you. From Hostage to Hero is her book, but this is a key point in her book that she explains. Asking permission, and this is something that I've had to sort of develop over the years because it didn't come naturally to me when I first started trying cases. Because we have this concept that the jurors are here, it's against their will, they have to be here, it's their service, their responsibility to be here. So what do you mean ask permission? They don't have any choice. Well, you give the jury agency and explain to them that you are going to honor their wishes to the full extent of your authority and your power as a lawyer. And of course, we don't have complete authority in this setting. There are two sides to the story. But asking the jury permission before you do major things is very powerful, and it starts creating a feeling of agency with the jury. So for example, you're starting off jury selection and say, I know a lot of people have hardships being here. It's not easy being taken away from families and things you want to do and work and all those things that are pressing on you. And I understand if you don't want to serve on this jury. And at the end, if you will just give me your attention while we go through questions so we can understand where you're coming from a little bit, I'll ask you at the end if you want to serve on this jury or not. And if you don't want to be on this jury and you let me know that, I'll do what I can to get you off, so you can go home. But we need you. So would it be okay to spend this time and ask you some questions and get to know you a little bit? And get affirmative commitments. You want people to raise their hand on this. And there's something very powerful when you're not looking at them as you're not treating them as cogs in a machine, but you're treating them like people. So would it be okay if I asked you some questions? And the permission has to carry through the entire jury selection because you get into some sensitive topics. And the way I've done it for a long time was just to tell them that. Well, I've got to ask you some sensitive topics, so please open up, basically. Well, when the topic, and every medical malpractice case has sensitive topics because you're going to be asking jurors about personal things. You can be asking their medical histories. I mean, HIPAA doesn't let you do that, but we're going to be in a room with a bunch of strangers, essentially, starting off, asking people about their health histories and whatnot. So in this case we tried last week, which was a one-issue case. It was a medical malpractice case, but we had one issue in the entire case, which was, did the defendants fraudulently withhold one piece of paper out of the medical chart? That was the entire question for the jury, but it really mattered because if they did, if there was a finding that they had withheld this document, then the statute of limitations would be told on one of our three claims, and it was a big claim. The skeevy, slimy defendants raised the statute of limitations defense before the last trial 2 years ago, and 2 weeks before trial they raised it for the first time in an amended answer to try to take out our major claim right before trial. Really dirty business. Mistrial, long story short, the lawyers who originally tried that got disqualified because we developed evidence that they had themselves engineered the fraudulent concealment. So a new law firm comes in, judge bifurcates the case and says we have to try the case, which was last week, on the issue of fraud. We have to get a jury to find if the defendant or the defendant's previous counsel fraudulently withheld this record. That was the whole trial. But what was interesting is that we had to also have a medical case within that to explain why would they want to hold this document back. Now, I'm going to do the opening statement in the next hour when we're addressing opening. But what was very good about this case and very useful was, although it was a voir dire selection, we still used some of these principles. And there's some very, personal questions about cancer and cancer survivors and experiences. So we would ask permission. I would ask permission of the juror and say, well, Ms. Johnson, you raised your hand about that you have somebody in your family that has been through cancer treatments. Would it be okay to ask you some questions about that? And they always say yes, but there's a feeling of agency because you're asking them permission. If they say no, it's not okay, you respect that. Say, well, I understand. Unless you have to ask it. But then you're in trouble because you've asked permission and they haven't given it and you're going to do it anyway. So you got to be careful. But I've never had somebody say, no, we can't do that. Now, if they say, I don't want to do it, because it's too personal, well, you give them more agency and say, well, then we'll talk to you privately as you've requested, and we'll get the judge involved and talk with you in that setting. So the asking permission, all these tie in together in my mind. They're all about engagement and about just treating people decently and viewing them decently, because when you see them just as a bunch of numbers holding up, we have to hold up paddles in Georgia, like an auctioneer's paddle. Hold the paddle up and flip the paddle up. You can lose that human connection. So number 3 is asking permission. Number 4 is the empathetic listening. I've got a horrible story to share with you to illustrate this point of how important empathetic listening is. So a few years ago, a friend of mine asked me to try a car wreck case with him. And, well, specifically, he asked me to participate in jury selection and help support him on the case, and I was happy to do it. So my friend Jim is speaking to the crowd, and he says, anybody ever been in a car wreck before? A few hands, and he follows up, pretty traditional stuff. Says, anybody ever had a close friend or family member injured in a car wreck? And this young man raised his hand, and yeah. Tell us about that. Well, I was in Iraq, and my vehicle was hit with an IED, and several of my buddies were killed, and a number of people were injured. Anybody else? Oh God, I wanted to melt into the floor. But he was so in his mind, and he was so in his notes, and he was so into the next question and the next, and checking the boxes, that he missed. I mean, there's so much wrong with that, but he missed an opportunity to really connect and to move in closer and say, well, that sounds absolutely, just horrible. Can I ask more questions about that? Sure. Well, this case involves a car wreck. Thank goodness nobody got killed, but there are some serious injuries, nothing like what you just described. Can you share with us how your experience might influence you if you were asked to serve on this jury? Because we need to know, and this is the time. Would it be okay for you to share some of that with us? That approach would be obviously more powerful than that. So you have to, that's just an example of not listening, because Jim is a wonderful guy, is a veteran himself, and it just was in his head. So it sounds easier than it looks, right? And we all think we're great listeners. We all think, that just comes naturally to us because we're lawyers, but it takes a lot of work. And I find that when I'm addressing a larger crowd, it's real easy to get into the sort of the surf mode, kind of dancing along people's heads. You're not really looking at them. It's a little harder when you sort of dial in. And you just, you look at somebody and you connect with them. And then if we have a conversation, we start a conversation, real hard to put the walls up around the other people in the room. It's just not a natural experience. It takes practice and training. And we do work with focus jurors, and we practice jury selection before trial to have that experience, because people know if you're surfing. People know if you're bobbing and weaving and you're not really connecting. But there's no reason you can't connect with anybody in the back of the room. But it takes eye contact. It takes I'm not a big fan of mirroring because if you're too conscious of mirroring, I think it can feel artificial, and every step you're trying to model. I think the key in effective, empathetic jury selection is eye contact and direct attention. Don't look away. I mean, don't stare them down, but direct attention, head nodding, those type of sort of cues. But nobody does focused, empathetic listening better than Oprah, so that's why I chose her to join us today. Here's a different thought, too, that we're starting to do in our practice, is to actually use visuals in jury selection. It is not written down anywhere that I know of that you are forbidden to show things to the jury that might be helpful to them. So we've started using visuals, actually showing a scale of justice, for example. Now, it doesn't have to be something up on an electronic screen. It can be a board. It can be your own body. David Ball does a nice discussion in his book about using your hands to show the scales of justice. And in a criminal case, it's way down here, and in a civil case, it's way up here. Whatever. Slight tilting. But in a big room with a lot of people, they can't necessarily see your hands. So we're moving more to using visuals to demonstrate some of the principles we want to talk about. We talk about the football going past the 51-yard line. Who can object if we're starting to show things that are interesting to the jury, and we're giving them examples of what our standard of proof really means. And you want to give things, information in multiple ways, the same information, because people just think differently. And in the trial we had last week, that point was sort of brought home because a juror told us during jury selection, I didn't really get the preponderance more likely than not until you said 51%. And she says, I'm a data person. I do data analysis at my job, and that makes sense to me. But then we got another interesting response to that where the person said, well, I can't stop thinking about the 49%. And I think if there's 49% on the other side, that's a whole lot. And I couldn't make a decision just based on 51 to 49. Valuable information. We got a causal challenge on that juror. So some other examples of visuals that we use. Very important to have an anchor board with your key players on it. And you can entitle it any way you want to, people you will meet in trial. But we try to, in our cases, have one board that has the pictures of the people they'll need to keep straight. So it works out really well when you're in trial because you can keep going back to this board. Oh, by the way, what happened? It's not working. This gentleman here, Mr. Peters, was the one who had gotten disqualified from the first trial. We were, not to spoil next session, but we were on the eve of his cross-examination. We were 3 days into our trial, and I was staying up late working up my cross-examination of Mr. Peters, and it was going to be really, really good. I was excited about it. And then I get the call from the defense lawyers who say, we're throwing in the towel. We're going to withdraw the statute of limitations defense. So I never got my cross-examination of Mr. Peters. But anyway, back to the board. So you can use this board during jury selection and start introducing people to the jury. The traditional way we've always done it, or a lot of people do it, is I'm going to just list a whole bunch of people and you tell me if you know them. Well, why do that? Why not say, let me introduce you to the folks you're going to meet at trial. Over here is Mark L. Deary. You'll learn that Dr. L. Deary is the chairman of the Winship Cancer Center at Emory. He's head and neck surgeon, cancer surgeon. He's been director of that department for 20 years and is also an associate professor at Emory. Does anybody know him or have heard of him? Now, you may get some objections, and they may be like, well, Your Honor, he's just, doing something wrong. And it shouldn't be. It's inappropriate. I hear that a lot. It's inappropriate. Well, Your Honor, I'm trying to put them in context. These are important witnesses in the case, and I want to, some people's memories might be jogged. It's like, oh, yeah, I remember Dr. L. Deary.